So, welcome to the session called Human Rights in the Digital Space. My name is Ken, I'm with Wacom, and with me today is Ignacio-Domingo. He's Chief Information Security Officer of Loyalty and General Manager of Astrea, la Infopista, Juridica, SL. Please apologize my horrible Spanish, and welcome, Nacho.
Oh, thanks for having me today. It's a pleasure.
Nacho, can you please give a brief introduction into the topic we'll be discussing today?
Yeah, today we're going to discuss about handwritten signatures captured electronically and how they can enforce the projection of human personality into the network.
Okay, so dear audience, because as you will probably already start to sense, this topic is at times a little bit philosophical. So we also invited Max, a live illustrator whose visuals will help us to understand this topic better. Hey, Max, so let's get going.
So the session is called Human Rights in the Digital Space. Nacho, what is the source of human rights in the digital space?
Potentially, the source of human rights in the digital space is the ability that you have to project yourself into the network.
Is he drawing right now?
Dependency on any third party.
No, it's also a video, right?
This is because when you have a dependency on a third party, which is exclusive, then you are not able to act on your behalf.
That's brilliant.
So to be able to develop your digital personality, your digital personhood on the network, you need to be able to be in the network without this exclusive dependency on any third party. This is something that relates also to the production of legal acts and the entering into commercial transactions.
So the subline of this speech is, who is the digital you, the role of handwritten signatures in online identity. So what role do handwritten signatures play in this context?
Okay, handwritten signatures are a form of electronic signatures. Electronic signatures are very important to be able to conduct business and to enter into all other relationships with people. We've had, signatures for a long time running in the physical world, and we should have the same in the electronic world, just to anchor trust. So if we are saying that yourself is to be transported onto the internet, you should be able to sign. And you should always also be able to identify yourself. So in this sense, handwritten signatures, if they were transported to the internet, would be somehow the most natural, the most human way to sign. So in this sense, it is important that we have legislation that recognizes this sort of electronic signatures.
So how do electronic handwritten signatures work currently in the digital world compared to the physical world?
Okay, in the physical world, signature is something which is biological. It is something that is produced by you because you are a human entity. And in fact, many scholars, they say that it is not only a biological thing, but also a behavioral thing. So it is commonly said that we sign with our minds, not only with our hands. So this is fine because during a lot of time, we've been using this as a binding mechanism, for instance, to declare your consent, to declare will. And it works for all around the world. So on the contrary, when you go into the internet, as you cannot directly put your arm onto the internet, we have created other technologies such as cryptography, and we have created the legal logic that something which is produced by you controlling a cryptographic device should be the same as your handwritten signature. But this is not quite true. I mean, any technology which is not directly biometrical, which is not something which is attainable to you from a biological sense, it's not a human act, but it's something artificial. So we have created a set of regulations all around the world to recognize the value of these signatures. But even with these laws, we cannot say that these signatures are purely human acts. So they are prone to identity stealing, for instance, issues.
So what is the legal status of handwritten electronic signatures right now?
Okay, that depends on the region of the world you look at. Majorly speaking, we have three big legal systems in the world. One big legal system is civil law system. In this case, we have legislation, barely in all the countries in the world, that are recognizing all forms of electronic signatures. That includes cryptographic signatures, as I was referring before, but also the possibility to produce a handwritten signature, which means to capture electronically your handwritten signature. which is this technique is recognized as a general matter of fact by civil law systems, and also it is recognized by common law systems. So today, you could say that from a legal perspective, the idea of capturing electronically your handwritten signature is legally binding all around the world.
Interesting. So why can't we use, say, fingerprints or facial recognition to enter those contracts? Why handwritten signatures?
Okay, this is a very good question. So the first thing I have to say is that you must remember that if handwritten signatures or any other technique is to be used as a signature system, it has to deal with consent. And consent is something that is related to written text. So if you look at how we have created the contract theory all around the world, you will see that when you enter into a valid agreement, you receive a text. Normally speaking, you receive a text, you can read the text, you can store that text because you need to remember the clauses you are adhering to, and then you must authenticate this text. So somehow the idea of signing has to do with a natural person consenting to a written text. So of course you can do this with any technology you want, but at the end of the day, you need the same set of components. So if you want to say that swiping your hand on a screen is a form of consenting, this is perfectly fine if you have a written text. But the fact is that, as I was saying before, if this is mediated by technology, then you must prove that this technology is really fit for that purpose. So if Ignacio Alamillo, for instance, is not able to understand that the biometric movement or swiping something or moving your hand does not imply consent, then it is not an electronic signature. So we can only say that the technology allows you to sign if a human is able to understand that this is the case. The other issue is that using biometrics to produce consent is not something which is appropriate or balanced in all cases. And in these cases, if you are requiring citizens to deliver biometric information without a proper justification, then probably you are harming citizens because you are collecting more information that is required. This is something we are dealing with the data protection regulations. And biometric information is one of the most sensitive informations for humans. So therefore, when you design an electronic signature system, you must be proportionate, because otherwise, probably you are generating harm to humans. And this is something which would not be acceptable.
Okay, but so now you're saying that also electronic handwritten signatures have their issues because they're biometrical information. So why don't we just use digital signatures?
Well, in fact, the handwritten signatures are the best signatures ever because they are the same signatures you produce in the physical world. So this is the argument in this case. So the rest of technologies might be somewhat similar. They could be more or less good enough as handwritten signatures, but it will depend on the technology. For instance, if the technology we use to sign is based on a smart card, for instance, which is something which is really deployed out there, this concept of a public infrastructure, this is fine, but someone can take your smart card and then they could sign on your behalf. So we have this kind of decoupling between the human and the signature. So that signatures are not human at all. So this means that they are not really interesting when going, for instance, to produce signatures all around the world with all kinds of citizens. So here we have some shortcomings.
Yeah. So you said this. It's about proportionality. So so it doesn't. So just because you sign a contract, it doesn't really justify all means. So to go all in with and store all the digital data and all the biometric data.
Yeah, that's the point. And also, if you're a company and you need to sign contracts, you want to sign contracts, you want to have these global processes to collect consent all around the world, that's fine. But it is a burden for you. If you collect too much data, it is also something which is bad for you, because then you have to store that data, you have to protect that data. So at the end of the day, it might be a good way to design a system. It is not really good for citizens. It is not really good for companies. So because we are requiring too much. So probably this is why the idea of capturing electronically handwritten signatures is potentially the best way to do that. It is the most proportionate way. It is the most human way. And that means that it is aligned with our constitutional values, irrespectively where country you are settled in.
Yeah. So what are then the conditions of actually producing then a good handwritten electronic signature? Because I assume not electronic signatures are the same.
Oh yeah. You're perfectly fine, right. So the idea is that if you want to collect a handwritten signature using electronic technology, you have to do it properly, because otherwise you are not going to have a proof. For instance, of course, you need good technology for capturing data. At the end of the day, a good handwritten signature, which is captured when it's captured electronically, it is based on the possibility of capturing a lot of temporal data series that will allow you to produce, a dynamic online verification of the signature, comparing your signature with other signatures, something that would eventually occur in court when you are adhering a claim or dealing with a claim. So you need good technology. And that's where the good tablets come in. Of course, if you don't have a good tablet, then your handwritten signature is not so good. This is one point. A second point is that, of course, for this pressure and the dynamics of movement signature is a key point. But then you have this very important data, which is the biometric information for the signatory, and you must store this correctly, because you should prevent anyone from accessing this information, because anyone having access to this information can reuse the information to produce false contracts. So you should encipher, for instance, the information to be sure that it is only usable in case we need to go into court. So you don't need only good technology such as good tablets, you only need good cryptography. You need to set up protective measures to be able to prove that no one did ever have access to this information, to this biometric information. Third, you need to prove which was the text that was actually read by the signatory. And you need to produce a binding, a kind of link between the text that was shown in the tablet and the consent. So you need to use, again, cryptographic technology, such as the use of hashing technologies, to create this binding. And then, of course, you need time. You need to prove when this consent was produced. So for this, probably you are also incorporating into the system technology such as the trust service called timestamping. And probably it is really, really important to use third parties that act as an interposition. They act by interposition, collecting the act of will and generating all the information and even storing that information.
So can you also give one example? Because obviously, so with a digital signature, it's very obvious how you can basically be identified, because there's a third party actually also controlling your identity. That is bad, but that also has value. How can you make sure that actually with your handwritten signature, that you can prove your identity then if it's contested?
Oh yeah, well, this is something that it is to be done with a technical proof. So in paper, this is something that has already happened during a lot of time. So I can sign a paper, and if I have to challenge my signature, then I will need to support a technical proof. So in this case, when going to court, I will need to produce a set of new handwritten signatures, and a specialist will check if that signatures have been produced by the same person. And then the judge will decide if I have to be liable or not because of that proof. So this is exactly the same way that handwritten signatures work in the electronic world. The difference is that we don't anymore check a physical graph. We don't check the ink atoms that are attached to the paper atoms. We check electronic data. So what we are going to do is to produce a set of new handwritten signatures captured in a tablet, in a good tablet, and then this specialist will check that the original signature that was captured electronically fits with the new signatures that were captured electronically. If that happens, then I will have been identified again.
Yes. Interesting. So I also learned that, so how does then the GDPR or data privacy regulations, come into this picture? Where do they fit in?
Okay, we've been talking about biometric biometric information, because at the end of the day, if you capture your handwritten signature electronically, then this is something that it is biologically produced for you. So it might eventually uniquely identify you. Biometrics are really very important data. It is sensitive data because it could be used for good or for evil. In that sense, it is one of the special categories of data that in many jurisdictions, personal data protection legislation wants to keep very secure. And this is obvious. If I can collect your biometric information, I can do a lot of bad things about you. I could just take your identity and enter into false contracts. I could open false bank accounts. I could do a lot of things. So this is why the most advanced data protection legislations in the world have decided that collecting too much identity data, this is the American approach, for instance, or to collect too much sensitive data should not be free, should not be a free decision of a company or even of a member of a state. So there should be a very important reason to do that, because it is a very important data. So in example, in the European Union, we have created this new regulation, the GDPR, which has decided that the biometric treatment should not be allowed except if you have a good reason for that.
But also electronic handwritten signatures and GDPR are sometimes in conflict, because electronic handwritten signatures are biometric data per se, right? So how is that relationship?
Okay, this is a very good question. So in fact, what we are prohibiting in these regulations, it's not any treatment of biometric data, but any treatment that ends up with a unique identification of a natural person. So it is not really forbidden to collect your biometric data. What it is forbidden or subject to very strict controls is collecting your biometric data with the aim of uniquely identifying you. So if I get your photograph and I store your photograph, this is biometric data, of course, but it is not biometric treatment according to GDPR, for instance. To be that kind of biometric treatment, and therefore prohibited except with consent and any other legal basis, what I would need to do is to check your photograph with any other photograph to try to identify you uniquely. So if I do that, if I check all your photograph with all the rest of the photographs on the internet to create a unique identity, then I'm doing a biometric treatment. And this is not allowed in the GDPR, except if you have a specific legal basis. Therefore, if I just collect your handwritten signature to store it and use it if needed, and I'm not checking your handwritten signature data with any other handwritten signature data, I am storing biometric information, but I'm not performing any biometric treatment. And this is quite good, because otherwise we would have a very strange situation, which is that the GDPR is there to protect you, but then it would not allow you to use your own handwritten signature, forcing you to get a new identity with a third party and therefore collecting your data to this third party.
How will the evolution of this digital environment affect digital personhood?
Oh, well, this is a very, very interesting question again. So the point is, now we are onboarding a lot of new people, because as technology evolves, networks are deployed, and new people is onboarding the internet. So now we are entering into spaces where we have a lot of people without access to technology, without access to money enough to buy specific types of devices on the internet. So they are entering a lot, all of them. And we need this to happen because we need to have people on the internet to be able to deploy global processes. And these processes are not just commercial processes, but emergency processes, fighting against pandemic processes, and a lot of them. So that means that now we have new cultural people onboarding the internet with their own, behaviors, their customs, and in some cases, their prejudices against technology. And on the side of the story, we also have a lot of newcomers, which are very different from our really technological advanced society baseline. So in some cases, they don't have any access to technology, but they still need to be on the internet. So how do we enter into relationships with people that do not have the last version of the most expensive smartphone in the world, for instance? Or how do we enter into relationships with people with no identity given by a state? For instance, there is a lot of people with no identity at all in the world, but they still need to act. They still need to be able to be on the internet and to be there and to be recognized, to enter into binding relationships. For this, we need to deploy human technology, not artificial ways to sign, but human ways to sign. In this sense, digital personhood might be limited depending on the technology we decide to use. If we decide that to be able to sign, which is to exert your digital rights as a digital person, you need to have a very expensive smartphone, then we are limiting the way people is able to act on the internet. Then we are modeling the digital personhood in an unfair way. And this should not happen, in my opinion. We need to use systems that would allow everyone to act as humans on the internet.
Article 6 of the Universal Declaration of Human Rights states, everyone has the right to recognition everywhere as a person before the law. To conclude our discussion, could you tell me how this right to recognition relates to the concept of electronic signatures?
As we've been discussing during this interview, to be able to develop your digital personhood, you need to be recognized essentially as being a human in the digital space. For that, we must avoid having any exclusive dependency on a third party. Therefore, the electronic signature technology we select has a consequence on being recognized or not as a human as a whole. Therefore, using handwritten signatures captured electronically is the best way to enforce and develop digital personhood on the network.
So thanks a lot for the discussion, Nacho. We see already quite a lot of questions, also very interesting questions, but unfortunately we don't have time as I have to run to another session, which starts in 8 minutes now, but I need to prepare a little bit. So I'm really sorry that we can't answer all the questions, but we will make sure to follow up with all of those. And before we close the session, I have one additional tip. Please go to the Wacom for Business virtual booth, because there you can download a white paper that was authored also by Nacho, which discusses a related topic. Well, thank you very much again, Nacho, for all the insights on this important topic. And thanks to all of you for your attention. Thank you very much. Bye-bye.